Hello, everybody. We're gathered here to discuss the Supreme Court judgment on denying marriage equality. And we've titled the session Decoding the Supreme Court Judgment. And the question really before all of us is, what is there to decode as far as this particular judgment is concerned? And in a legal sense, there is a lot to decode. And in a political sense, I think there's even more to decode. And the reason for that is because the Supreme Court is not delivered. There are four judgments delivered by five judges. And sometimes we just have a clear majority and a clear minority, and we can easy to make up your mind. But here the difficulty which leads to the problem of decoding is among the five judges, there's some issues on which all five judges agree, some issues on which three judges agree, and so it's a complicated web of judgments, and we have to really decode, even in one judgment, on what points do the judges all agree and what points do they disagree. And that's the difficult part as far as the decoding question is concerned. And just to quickly take you a little bit through, it is the broad frame of what we're trying to decode in this case.
It's clear. I mean, we can hear. I don't know.
Yeah, we just got a message saying it's not clear. Okay, fine. So if we go down the question of on what are the points, there are at least 5 points on which all the judges are agreed. Let's look at what the points on which they agreed. Let's look at the points on which they don't agree, and then I'll open it out to a really wonderful panel to look at the balance between the majority and the minority and see how they understand the particular judgment and how they want to take it forward. The point on which all the judges agree is the first question, of is there a fundamental right to marriage? All the judges agree that there is no fundamental right to marry. The second question they go to is, what about the question then of the Special Marriage Act? Can we interpret the Special Marriage Act in a way to include the LGBTQ community by either interpreting it in gender neutral fashion or adding the word spouse? And again, all five judges agree, no, because the spider web of legislation, if you change one law, a whole range of other laws change. Therefore, we're not going to go down that particular route. The third question on which all the judges agree is the question is there a recognition, or do transgender people have the right to marry? Again, transgender people defined very specifically as if you're a male to female transgender person, you have the right to marry a male, and vice versa. So it's a recognition of a heterosexual relationship within the transgender context. Again, that's a narrow recognition, but one recognition on which all judges are agreed. The fourth point actually on which all judges are agreed, and this is an important point as well, is all the judges are clear that the baseline laid down by the Supreme Court in Navtej is something that they're sticking to. That the question of violence or discrimination against LGBTQ people is something which is not to be accepted. They make the point that LGBTQ people have the right to life, have the right to establish relationships, have the right to live in with other people, have the right to form associations with other persons, as it were. The final point they agree on is that the committee should be established, a high power committee chaired by the cabinet secretary to be established by the central government to take forward some of the issues of discrimination which LGBTQ people face in the context of unions or relationships. This is what they agree on. What is the point on which they disagree? The point on which they disagree are really two very fundamental points. The first point is, okay, fine, under your right to association, on the right to express yourself, right to relationship, you establish a relationship. Once you establish a relationship, many rights flow to you out of that particular relationship. And here what the courts hold, what the minority holds by Justice Chandrachud and Kaul, is the fact that your right to association under 19(1)(c) includes your right to intimate association. And your right to intimate association, both part of your right to life, as well as your right to association in 19(1)(c), as well as your part of your right to conscience under Article 25. And as a result of these three rights, the state is obligated to recognize the bouquet of rights which flow out of this kind of a relationship. The second point on which the minority agrees is the fact that you are entitled as an unmarried couple to exercise the right to adoption, and the Kara guidelines to be read accordingly. That's what the minority puts forward. Of course, the majority is very strong and vociferous in disagreeing with this particular proposition. So this is the lay of the judgment, as it were, with the majority and the minority. And putting this as the background, as this is what we're discussing. And of course, we'll discuss this both from a legal lens. First round of questions I'm going to ask all our panelists is, how do you respond to this particular judgment? And the second question will come to is, okay, fine, this is what we have now. How do we want to take our struggle forward in the future, as it were? Those are the two questions I'm going to ask our panelists, but I'll quickly introduce who our panelists are. And before we get to the two questions, our first speaker is going to be Mihir Samson. Mihir Samson is a lawyer who's been associated with the LGBTQ movement and struggle for a very, very long time, ever since the decriminalization days, as it were. Currently, he's running a practice in Delhi with his partner Amritananda, and really in terms of support for queer people in the Delhi context, Mihir and Amritananda are the people to really go to. As far as this case is concerned, the important role that they played is, if you look at the adoption dimension of the judgment, it comes, I think, significantly, substantially from the arguments put forward by Mihir and Amritananda in court, where they've really made a very strong case on the adoption dimension of the question. And one other last point of introduction in terms of their argument, their petitioners, I gathered, are a queer couple, Kajal and Bhavna, who are an inter-caste couple. And it's very interesting that during the arguments, the senior counsel who argued the matter made the point that when you go back to the Indian Constitution and go back to Justice Vivian Bose's statement, where it says the Indian Constitution is not just for the rich and the elite, it's also the butcher, the baker, and the candlestick maker. And Mr. Ramchandran's submission was, the baker in this case is the lesbian baker who is Mihir's petitioner, and the Constitution should apply equally well to her. But of course, that's not the way it went in the final analysis. But Mihir, with that very brief introduction, do you want to just take us a little bit through the judgment and your analysis of this particular judgment?
Thanks very much, Arvind, for that kind introduction. So we represented two lesbian couples before the Supreme Court. The first is Kajal and Bhavna, who are the intercaste couple. And for them, actually, the issue primarily was one of safety and security. And what we really wanted to do by participating in this case was to kind of make sure the court understood that the daily life of persons who are in conflict with their family is so precarious, so that when we're asking for marriage, it's not a matter of social acceptability. You know, you'll see in Justice Bhatt's sort of end paragraphs where he asked the government to look at social acceptability and take measures, but that was not the point. You know, social acceptability may or may not come. The point is that actually on an everyday basis for them, it's a matter of life and death, because in 2019, they ran away from their home. They were hounded by one of the girls' families very, very seriously. We had to rush to the Delhi High Court and get protection. Now, the problem with protection is, of course, that it really is dependent on where you're staying at the moment when you ask, you petition the court for it. So as they moved on and finished their education and got a job, their daily life was a big struggle, because every time they moved into a different room, the police would send this verification request to their families. And so then the families would come, make a big ruckus, make all sorts of wild allegations that they were using drugs, etc. And they had to then move place to place. So actually, they've been in a state where, you know, on some days they may not have enough food to eat. They're always worried about their security. And for us, then marriage was not, you know, this broad bouquet of earned rights and what your partner might get on your death, etc., but trying to give them an additional layer of protection that could keep them alive in the face of this kind of family violence. Amburi and Aparna, on the other hand, both had jobs. They found the legal regime very hostile, so they moved to Germany and got married. And they were very keen to come back and adopt a child. And that's why sort of the adoption arguments became a focus in that case. And it was felt that maybe their marriage may not be recognized. They are married abroad in Germany, but irrespective, they should have the right to adopt a child and start a family. And that's why the challenge to the regulations of Kara, which require 2 years of stable marital life as a basis for adoption. Now, in terms of the judgment, I think the most disappointing facet is the fact that all 4 judges who have authored judgments, agree that there's no fundamental right to marriage. And I think this is a backsliding in terms of what the court has said previously. And it has very serious implications for intercaste couples and interfaith couples who have been with us at the police stations regularly, also facing extreme amount of violence. And all the previous jurisprudence is actually in that context. So you see in many cases where Khap Panchayats are holding meetings and there has been caste-related violence, the Supreme Court affirming the right to choose your partner. And up till 2018 in Shafeen Jahan, which of course the Hadia case most of us are familiar with, where the Kerala High Court dissolves her marriage because it's very concerned about what's happening and attributes all sorts of motives to her husband. Justice Chandrachud himself says you have a fundamental right to marry a person of your choice. He frames it in a specific right to marry manner. And that was one of the lines of arguments. I don't mean to say that, if we lost on the existence of the fundamental right to marry, everything else falls. But it was very much based in the domestic jurisprudence of the court, not just, as the court, the judgment it implies that we were relying on the US and South Africa and Canada, etc., much more. But it was very much rooted in Indian jurisprudence. In fact, this judgment authored by Justice Chandrachud. So you see here them getting out of that by saying that no, the focus on the right is that right to choice. So what is fundamental is the right to choose your partner, but marriage itself is not fundamental. It kind of distinguishes that. So I think that is now a step back from where we had reached with Shafeen Jahan particularly. You would also have a lot of elements, as Justice Chandrachud recognizes in this judgment, of marriage protected. And that we see in Navtej, for example, the right to choice, the right to dignity of recognition as a partner, etc. But together they conclude that there's no right to marriage. I think a matter of concern here is the way Justice Bhatt has gone about his analysis. He says marriage is pre-state. The state is not something that has created marriage. And therefore, state intervention in marriage has to be to a limited extent, 1. And 2, if there is intervention, it must be through law. Now, this is a very sort of unusual analysis, because are we supposed to just now let all pre-state institutions be unchecked as if the Constitution has not been enacted and they're not subject to the rigors of the Constitution? And 2, it kind of ignores our arguments where we are challenging the law against the Constitution. And so, I'm doing here what Justice Chandrachud says you can't do, but I think in this analysis, one misses actually the beauty of the Special Marriage Act. And what the Special Marriage Act does is that of course, its earlier version was in 1872, but pre-1954, the real governance of marriage is very much in religion. And the way the 1872 law first was enacted was to say that you can get married under secular law, but you are kind of removed from your religion. And then an amendment takes place which kind of waters that down, etc., and you move along. But in the Special Marriage Act, they do really entrench the fact that not only does religion not dictate who can get married, uh, so it's interreligious, intercaste, etc. But it also takes away the fact that you must get married at a particular venue, such as a church, which is sort of mandatory in some religions. And you must get married as per specific uh, custom and ceremony. So in that sense, the Special Marriage Act divorces from religion, religious practices, and religious dictats the entire sort of institution. So for Justice Bhatt to say that this is a social institution, which is far removed from the regulation of law and far removed from state intervention, it just does not seem to sit with the historical development of the law at all. And I think Justice Chandrachud gets it a little bit more correct by saying that it's a sort of social legal institution. But of course fails to then go through in terms of whether the guarantees of the SMA are applicable to queer individuals. So I think in terms of the finding on the fundamental right, the majority has got it seriously wrong, and it has even failed to follow its line of judgments. Justice Bhatt also seems to be very annoyed with the petitioners because he sees us as trying to compel the court to, one, create a new institution which confers status on people. And I think that's interesting because, one, we were actually claiming either to be within the Special Marriage Act particularly, and two, it misappreciates what they did in Nalsa. In Nalsa particularly, trans people had no status as transgender persons. They were forced to be in their gender assigned at birth. And the Supreme Court, through a judgment, which Justice Bhatt says is not possible, confers status as a chosen gender identity. And he says we cannot create status where people will be forced to relate to you as a couple, as a married person, even in private settings. But it's already been done in Nalsa. So I'm surprised about that as well, particularly. I think on the challenge to the Special Marriage Act, again, I have a slight distinction from the way you phrased it, Arvind. I don't think there's agreement necessarily that they cannot give the declaration, because Justice Bhatt actually finds that the law is constitutional because its object was to facilitate faith marriages. And that's an objective which holds water even today, and therefore the classification that it makes is valid. Now, I think that's incorrect in terms of its analysis, because I think the jurisprudence on equality has moved on quite substantially. And if one were to use, for example, the test in Navtej about does it subjugate a set of people? Does it not facilitate their entry into a particular good or service that other persons are allowed to access? I think then it definitely fails. It also fails on the differential treatment of people on the ground of sexual orientation and gender identity. So though Justice Bhatt actually recognizes that the constitutional law has moved on because of Nalsa and Navtej, he's unwilling to apply it because he finds the objective of the act still holds good. I think that's not correct. Whereas Justice Chandrachud says that the remedy you seek is just too messy, and therefore we're not going in. I think that is something that we would have to deal with, because I don't think we can take issue with that, because it is actually quite messy. We try to simplify it. We try to project it in a way that actually our central challenge is basically that Section 4 of the Special Marriage Act, which says who can enter into a marriage. In the main part of the section says any person, but later down in the subsections, it has differential ages for the bride and the bridegroom. And so in the court's analysis, every section which would then follow would also require a constitutional reading down or reading in, etc., which they were unwilling to rewrite the section, the law. And I think that's something we would have to answer for. It is something that we have been grappling with through the hearings. And it's not, I would say, completely unfounded, that concern. But I think Justice Bhatt does not even get there because he's upheld the law's classification completely. I think it's because of this messiness, Justice Chandrachud gets to the point of the right to the union. And I was kind of chuckling because I had this very strange experience a few years ago in the police station where I had got police protection for a couple. But when I went to the SHO, he said, I will assess each person individually. They have no right as a couple together. And I will see whose family is doing the threats. Completely ignoring the fact that actually what's making them vulnerable is their relationship and them being together. And so I thought how interesting that, finally it's translating from the police station into the constitutional court, where actually there's a need to recognize how much violence comes from a lack of recognition, even of a relationship with any kind of status that one might accord to, even the respect of a basic status as a union separate from just a relationship. And I think Justice Chandrachud is trying to find a way out, which I acknowledge, and I think it's an interesting way. And I think part of the credit very much goes to Chayanika and the petition that they pioneered in terms of asking for recognition, both within marriage but outside, in terms of non-sexual and romantic partners, etc. And I think that kind of thinking has allowed for this line of arguments of Justice Chandrachud. It's a pity that the majority says that even this is not permissible and it has to go, it requires a declaration from the state. And I think that actually is quite sad because Justice Bhatt recognizes how much violence there is and recognizes how much discrimination is, but is still unwilling to give a declaration on the basis that this would also mean that you're recognizing status on a couple. And there, I think you see legalism sort of defeating what would be a just outcome. And it's really quite disappointing. So to me, what we are left with really are the declarations and directions by Justice Bhatt and Justice Narasimha, which really are that there is protection for couples in terms of previous judgments, which include Shakti Vahini. Now, Shakti Vahini sets up a sort of shelter home in each district where you can alert the district administration. We had kind of mentioned that actually that's very tough for queer couples because no queer individual is in that institution. Which is very different from the Garima Grace, which has queer organizations running the Garima Grace under the transgender rules. And we have a declaration that no medical procedures can be carried out without consent. But apart from that, we have very little else.
Yeah. Thanks, Mihir, for that really comprehensive kind of a response to the judgment, both from a grassroots level perspective of working, as well as an analysis of the majority and the minority judgment. I'll turn now to Chayanika Shah, who's a queer trans feminist, part of a group called Hasrat-e-Zindagi, Mamuli, and again, been active for a number of years, many years, on the entire question of LGBTQ rights. And in this case, as Mihir has already indicated, Chayanika is one of the petitioners. So again, as a petitioner who is there in court, who's seen the way the proceedings unfolded, what is your response really to the judgment which we got? You have to unmute yourself, Chayanika.
Thank you for bringing us all together to have this discussion. As you said, it is a complicated judgment. And from last Tuesday to this Tuesday, I think we've gone through many ups and downs. At moments, you feel very angry. You feel, what is this? They've given us nothing. At moments, you feel there are things that can be resurrected. And at moments, you feel that, oh, this is part of life and it's going to continue. But to come to the judgment, before that, I want to get into the fact as to why we became petitioners. And I think that's pertinent to also what Mihir was indicating as to that there was a way found because a certain approach was taken. And I come from a feminist background. I'm very critical of the institution of marriage. I definitely will not enter one, even if it's given to me. And yet one has gone into this petition. And that itself is a conflicting thought in one's head. But the point is that what we went with was asking the right to make a family. And again, I wouldn't want to use the word family, but that's a word that is understood by everybody. So a right to actually move away from those that are legally seen as my own when they are violent towards me, and move to saying that, okay, these are not my people, this set of people are my people. This is what propelled us to come here. And as Mihir rightly said, in our petition, we had, along with the four of us, we were representing a network of lesbian, bisexual, intersex women and trans persons. And this network has been actually working, helping couples, and Mihir and Amrita are very much a part of that. So also many other organizations. I say many other, but we are very few actually across the country. We find couples running away all the time because they're being forced to get married, because they're being, there are all kinds of violence that they're facing. And one of the reports that we did along with PUCL is something that's on the PUCL website. And I think that was one of the main documents that we used for the petition itself, which said that there is, and I think the report was like a Jansunwai in which Mihir was there, other people were there. And that report kind of said very clearly that people should also have a right to exit the family. And I think we need to understand this, that the only way that I can exit my siblings and my natal family is by actually getting married and creating a new set of people who become my family. There is no other way that I can get out of this. So one of the things that we were going on asking is that how do you recognize the people who actually nurture and care for me? One way to do it is marriage. And of course, in a society that is so compulsorily oriented towards marriage, people do want marriage. I am not going to say that there can be no marriage. So we were asking for multiple options. One of them was marriage. Another was saying that recognize our chosen families, which we were not even going into saying union of sorts, which thankfully Justice Chandrachud and Justice Kaul picked up and made it into a union. And I'll come back to that. But we were asking for a recognition of me choosing that this is my chosen person, or these are my chosen persons who will take decisions for me in the absence of when I can't take my decisions. It's that minimal. And I think that prayer has been lost. It is not actually something that has been picked up by any judge. It's not been opined on. Chosen family is referred to, but this specific demand has actually not been answered either by the respondents or by the court themselves. And we'll have to think as to what do we make of that. Coming back to the judgment, I think that I have now been around for very long, and I remember, and Arvind, you must remember, that in 2001, when the first petition was filed, the second petition was filed in the Delhi High Court, asking for reading down of 377, we were all confident that it's not happening in our lifetime. And we've seen what has happened in our lifetime. We've seen how much it has changed from 2001 to 2023. We are seeing how much it has changed from 2013 to 2023. And I really, as an activist and as a person who is talking to people, I really feel that we are misrepresenting the judgment if we only talk about the fact that all of this is denied to us and we've got nothing in return. I think that we've got a lot in return. It could have been much more. I don't want to mince words to say that they have let us down. They have let us down. But then, they're part of the mainstream society, and this is as much as we get from a society that is so conservative otherwise. And I would advise everybody to read Tushar Mehta's arguments as summarized in the judgment to understand what is it that we are up against. And I think that this is not a question only to queer trans people. This is a question to all of us, that this is what they understand marriage and family to be. This is what they're pushing down our throats. And this is what is being contested. So I think that a fight is much larger. In that larger fight, even this, what Mihir is saying is a setback, that we've gone back on the right to marriage. I don't know how it will be interpreted by these characters. I look at the minority judgments, and I feel there are 2 points that I want to make. And this, I know as lawyers, you feel that there is no importance to the text of the judgment. But as somebody who's reading the judgment, I feel a little calmed down, because I think that at least somebody got us. At least somebody understood what we were trying to say and try to make an effort within that. So I would say 2 things. One is that there's a clear indication in Justice Chandrachud's writing, the main part which lawyers say we should not look at because it does not matter. But that part actually says that marriage is a heterosexual institution. It is a patriarchal institution. It is built on a hierarchy, and it is built on power hierarchy between the man and the woman. And there are specific roles that people play. And that also is one of the reasons why he's saying that right to marriage is not what one can ask for. Or there's no right to marriage, because this is a narrow understanding of marriage that exists in all laws related to marriage. And I think to an extent I would agree. He goes on to say hence that because there are tangible and intangible benefits of marriage, and in which I would put this whole basket that we were trying to say, that recognize our lives outside of our families, assigned families or natal families, recognize our relationships so that we can escape the violence of our natal families, so that we can exit those families at least temporarily. And I'm not talking of older people like me. I'm talking of younger people. I'm talking of people who are really vulnerable, who are dependent on their parents. They need a way out. By the time we reach my age, I think I've managed. I have managed to live my life. I have a lot of privileges. I know that it does not matter to me whether my family supports me or does not support me. I can survive. I come with that privilege. But there are many others who don't, who are younger, who are coming from marginalized backgrounds, who are facing a lot of trouble. They need the support, and they need the support from the state. And I think that this bit that all judges say, that the state is responsible for protection, I think that that's a valuable step for us to take. But the second point that I wanted to make is what Justice Call writes. And he says that maybe heterosexual people have a lot to learn from what will happen when there are unions and families that are constructed which don't start with preconceived notions of gendered roles. And I think that is a vision forward. That is where I would like to take this forward. That is what I want to take from this judgment. Much as I feel that finally, yes, I agree with Mihir that there are 4 judges who spoke. Not 4 judges, actually only 3 judges who spoke during the court discussion. 4 judges who wrote. 1 has just signed on, and I think it was very bad optics for the bench. But anyway, of the 3 judges that were active in the courtroom, 2 have got us. I want to even go with that. I want to take that as something that I want to build further on. And this is not in the courtroom. This will be outside the courtroom. I know it doesn't hold in the court, but this is valuable. This is valuable that 2 Supreme Court judges actually say that sexual union is something that you have to give. It is not dependent on the committee. And I would disagree there. The committee is there only to determine what kind of benefits have to be given, what is the extent of benefits to be given, but the union has to be recognized. If it is not recognized, that is discrimination is explicitly mentioned. So I do think that is a gain for us, that 2 out of 5 actually say that is a gain for us. The final point I want to make as far as the judgment goes is that, the point that I said, which has not been addressed, I would like lawyers to say as to, is it not necessary for people to at least say that we don't want to look at this, or this is not viable, or this is not. So what we had asked for is that we want to appoint a person like the Mental Health Care Act, as an advance directive, to ask for somebody who is not related by blood or marriage to make decisions on mental health care. Similarly, we want to ask for appointment of legal representatives. And I don't know whether we can ask for clarification. I mean, this is something that we will talk about, we will discuss and see how to think through this, whether we want to leave it for the time being because the whole environment is not conducive to us and pick it up later. We don't know. But one of our reasons to go there was to expand the discussion till we entered, until all of us, whether Akkai, whether Mihir, whether us, many others, we entered, we actually messed. We messed with the normative voice that had been filed before that. The normative voice was of privilege. The normative voice was of people who had everything, just wanted the legal right. And I do think that this is also something that we will need to talk about, that who goes and with what. And then if none of these other voices had come in, who knows what the judgment would have been. I don't know. When just wonders and, things that we don't know what they would have said. If they'd only heard people who said, we'd had Amendi and we'd had this ceremony and we had that ceremony, but we are very upset because we don't have a legal right. So I do think that this is something that we need to think forward.
Thank you, Chayanika, for that very incredible presentation. And I think in a sense, you're taking us to a next phase. You're saying we're looking at the majority, we're looking at the minority, and we're seeing the minority judgment and how we can take forward the strengths of the minority judgment with Justice Chandrachud and Justice Kaul. And it reminds me just in one line of Justice Khanna's dissent in ADM Jabalpur, where he says, a dissent in a court of last appeal is an appeal to the brooding spirit of the law and is an appeal to the intelligence of a future day. So I think you're invoking that, not just in the court, but also outside the court. So thank you for that. And now I'll go to Dr. Akkai Padmashali, who's a very well-known transgender rights activist and taken very strong positions on the marriage question in the public sphere as the petition went on. She's, of course, also a petitioner in the court. And just for the information of people who read the judgment, if you read the judgment, there's one section of the judgment where Justice Chandrachud makes the point that queer people are not just elite, they exist in all strata of society. And he particularly references Dr. Akkai Padmashali and references her work and says that she's a representative from a working class background who's also part of this debate. So again, important perspective here is Akkai, Jaina who filed the petition on behalf of Akkai, changed the narrative. That shift in the narrative is to say that this is not a case of same-sex marriage. This is an argument for marriage equality, and transgender people are part of the argument as well. So Akkai filed the petition from that perspective. And again, thank you so much for being here. Akkai, the floor is all yours.
Thank you, Arvind. I think as part of my conversation with Vivek Diwan, Chayanika, Arvind, Ramki, and Mario, and many other people that I belong to, and sitting next to me, right side, is Abida Begum, who is born intersex, and she's also the president for Karnataka Intersex Association. She's Teju. She's interning with my organization called Vandere. Yeah, I just wanted to introduce you people. I think I want to extend or take this way forward of this conversation. I think Arvind has asked two questions. What is your opinion on the current judgment is concerned? I think I want to endorse what Chayanika has said. We are disappointed. We are really disturbed. We have no voice to speak about this issue. The other aspect also, I want to welcome this judgment. Why I want to welcome this judgment? It is a next level of activism so that every community member can converge together to strategize for the upcoming movement. How do you fight as a community together, keeping our differences from the context of the elite, the upper class, the working class, the middle class, and non-English speaking to the people together, that we should come together to re-strategize. I think what should be the way forward? I think I would want to say that, going back to my recent letter that the 15 people from the working class, non-English speaking, we wrote a letter to the Prime Minister of India to address this judgment, stating that we are very disappointed about this process that the Constitutional Bench has rejected the police of people's issue, in upholding the constitutional rights is concerned, even when the court has said this is a business of the state, means the parliament and the state assemblies, I think we are also questioning to the Prime Minister of India saying that how can a system of legislature not even have a single person who represent the sexual minority community in the parliament? That could be Rajya Sabha, Lok Sabha, that could be in the assembly or the council is concerned. So we were talking about the political representation of sexual minorities. Second thing is also to address this judgment as an utmost serious matter. Even though it is referred to the Secretary of the Cabinet to constitute a committee under her or him's chairmanship or chairwomanship, even how many of us will be going to take up this issue? Number one. Second thing, I really doubt that this won't happen. Why? Means because upcoming elections are Lok Sabha elections. It will begin from March/April. But in Karnataka state, what we are really strategizing, along with having series of the consultation with the working class section of society, that we wrote a letter to the Chief Minister of Karnataka, and is very much serious to speak about this judgment. The inner dialogue that happens within the state circle, that even if they're not ready to go for a law, at least have a policy which can speak about same sexual relationships, same gender relationships, talking about the entire existence of issues of intersex people, transgender people, and sexuality minorities are concerned. I think even this disturbed a sort of what it has come out. Yesterday I was at Murgha Rajendra Mata. How do you bring the religious perspective to this judgment? I think many Swamijis who are part of this conversation yesterday, they supported this move. As what Chayanika mentioned, now our business in the court is okay. That let's stop for the next 5 years. Please go back to the society, talk to your families, friends, education institutions, talk to your police authorities, talk to your political leaders, talk to your political parties. Build that momentum of supporting or empathizing the movement is concerned. And also this judgment is something that's supposed to be spoken from the context of people's life, knowing that we have done a mistake. As Akkai had done a mistake, Chayanika has done a mistake, I think Supriyo has done a mistake. We have not came together to even understand what is your petition and what is Akkai's petition. Knowing that we are a very, very diverse community, each one of us in the section of society do have our own struggles and challenges and sort of that. But how I think some maybe we didn't come. And going back to some of the states that I belong to, especially these southern states, now transgender people are becoming so homophobic, saying that it's only transgender issue, it's only transgender woman issue. And they're not even talking about transgender men issue or the intersex people issue. I think this has really led to, this judgment has really led to bifurcate the movement and speaking in their own context of, I'm a lesbian, this is my group. I'm a homosexual man, this is my group. You're a transgender person, this is my group. I think if you go back since 1998 till 2018 judgment, I think the movement was together. I think upholding these rights are somewhere the court has disrespected people's life. I would really say that. And second point that would be about, I recently got this message that the Allahabad High Court, it has delivered a judgment on living relationships. And it has told living relationship has no integrity. It is just for time pass. So, and there is no sustainability. After this Constitution Bench verdict, the Allahabad High Court is giving this sort of judgment. There will be a social shift in people's thinking perspective. Going back to Justice Indu Malhotra, she quotes, she says, history needs to owe an apology for the movement of sexual minorities as well as their parents. So now it has been overturned. I think we are really, living in a very far, way of taking up this to the next level of issue. And I want to conclude here, Arvind, saying that our sambandha, our relationships are beyond the law and beyond the society. Thank you, Arvind.
Thank you, Akkai. Thank you again for the really, really fantastic articulation. And coming in a sense, you bringing the sense of the grassroots in the community into the debate. And that's a very, very important step forward. Thank you so much for everything that you said. And I think everybody in the audience has really appreciated your thoughts. And we'll take this forward in terms of the next phase of the discussion, which is fine. We've arrived at this kind of a crossroads, if you want to put it in that particular fashion. We have this particular judgment, which is some parts good, some parts bad, very complicated. What is the way forward in the range of possible ways? What is the way forward through the law? What is the way forward through social movements? What is the way forward through political parties? That's the kind of challenging space we are in. I know there's no easy answers to this question, but I think that discussion should really begin in some ways among all of us. Mihir already cautioned me, said that, it's very tough to think of a way forward in the context of the law. But Mihir, if you want to just articulate a little bit of that, just so people understand, it's a 5-judge bench. What are the implications of having a 5-judge bench decision of this kind? And do you agree with Chayanika and my limited attempts to say, let's push a little bit and see what we can get through the court while thinking of work outside the court? So two questions for you. What is possible within the framework of the court? You are, of course, engaged in a range of matters at the grassroots level. And so how do you think we can work to try and take that work forward using the court?
Well, I must acknowledge that Chayanika is always pushing the lawyers, and I think the lawyers are only benefiting from that. So I take the point, and I think maybe I would acknowledge that for people from our community, hope is very central to getting out of the immediacy of violence. And for young people, I think there's a big sort of concern that if they are able to leave, they will be met with hostility in the law. So they already met at hostility, of course, from the family chasing them, but there's also a lot of hostility from the police stations and also hostility from a lot of the judges. And a lot of our work is very much just going there to enforce the very simple idea that if you're an adult, you can choose where to be and who to be with. And I think a fraction of the people run away without the certainty and assurance of the outcome. And a lot of people actually are just so worn down by the everydayness of the violence that the thought of leaving is just too tough. And I think here where this major pushback has come, I think we'll see a lot of people really struggling to leave. And I think there, I certainly do take Chayanika's point that we must identify sources where we can reiterate that there is hope to live life without extreme violence. And I think the acknowledgement from the judges that the state is obligated to ensure protection is something that we must really build on. I think that there will be pushback because till now we've had such emphatic judgments in terms of Nalsa and Navtej that if there's any judge who's sort of very concerned because a lot of our lives are very messy, we might be in relationships where one person has been in a forced marriage and so they're cheating on their wives, etc. It's really a lot of stuff that the morality of judges also does come into play. And we've had such emphatic judgments that there's no question about, ensuring that adult people's wishes are respected. And I think here that where there are doubts from a judge, I think that this sort of disagreement might play in. But I think the law, of course, continues to be, Navtej and Nalsa have been reiterated and reaffirmed. Shakti Vahini, which actually applied to heterosexual couples, predominantly intercaste and interfaith couples, in one sense has been extended, right, to queer couples. So that's a new infrastructure that will have to be established. It is actually very scary in terms of districts where everybody knows each other. The district administration might be in a remote place. And so, and if emergency has broken out and you've been outed in the middle of the night and you're a woman, which has happened, we get calls from all over India. you might be taken in the middle of the night. So there suddenly to have, a Shakti Vahini kind of safe house, how will it look and how will it be something which assures a queer person that they can actually avail of that service? I think that's one place where which would require work, and I think if there's a note of caution, we already see that the Garima Grahes, which are set up under the transgender rules, we've had police raiding in, going in Delhi, in Gurgaon, and really creating a ruckus and forcibly taking trans people and taking them back home. So that battle is very much front and center in terms of our concerns. And I think this judgment, because there's a universal acknowledgement of the violence, does allow us to continue to have conversations with people who are needing and wanting to leave, and give them the hope that things can be better. I think in terms of in court, the parties, the petitioners, the lawyers do have to consider whether, as we did in Suresh Kumar Kaushal, whether we file a review petition. Of course, the grounds available in a review case are very limited. Whether Justice Bhatt's retirement creates a space for reconsideration or not is something that one has to think about. And that's a 30-day kind of time limit for a review petition. And then if the parties so decide, they are entitled to also ask for a curative to be considered where the 5 senior most judges of the court look at it. So that's something that we have to discuss with the community. Also, the lawyers and the petitioners have to discuss whether those specific remedies are availed of, whether there's any space in the disagreement amongst the judges to kind of say that no, the minority was actually right on these points, etc. Maybe Chayanika's, the point where you're raising that you had raised an issue, it wasn't decided. I think in a technical sense, one considers it deemed to be rejected, if I'm not wrong, but certainly there's a space for non-consideration. It's one of the grounds for reviews where it had not been considered at all. I think you see one passing reference to a nomination in a bank form in one of the terms of the committees, but nothing more than that. So that specific legal, the remedies, we'll have to discuss whether we take them. At the moment, we are still sort of grappling with taking out sort of what the judgment means in the majority and what we get from it fully.
Thanks, Mihir. Chayanika?
Yeah, I think the way forward, I agree with Mihir completely. I'm not wanting to be this hopeless optimist, but the point is that people are very disturbed. People are facing the backlash already. They're facing comments on their social media. They're being told that the Supreme Court is not with you, etc., etc. So it's important. It's important that we put out that we moved somewhere from 2018 onwards. The courts have moved a little, and that is the message that we need to give out. That it's not like we've gone back. Yes, we've definitely not gone back. We've definitely not gone the way that we wanted to go, but we've moved ahead. And I think that that's an important point to keep making and keep talking about. However depressed and upset we are with the judgment per se. The second point, I think I agree with Akkai. I agree with Akkai that communities need to talk to each other. Queer trans communities need to talk to each other. It's not as if partnership demands came out of the blue. Partnership demands, as you know, have been on the table since 1997, since the Hamjinsi booklet came out. And some of us are witness to that history. So since that time, we've spoken of decriminalization, we've spoken of partnership rights, and we've spoken of anti-discrimination. It's interesting that now all of these are part of the mainstream debate. And I do think that is a point that we have to take forward. The demand has come, the demand of protection from violence has come from trans people, and it has come from lesbian, bisexual women, more and more. It hasn't come as much from gay men. I'm not sure why it has not come. I'm not saying that there's no violence, but it has not come out in the foreground in the ways that it has come, especially from LGBT people and from trans people per se. The demand of trans people that we've been seeing in the last 5, 6, 7, 10 years, whatever, has been around issues of education, employment, health, basic needs. And I think that these also need to be foregrounded, because the point that we're making is that we don't have a family to fall back on. When we don't have a family to fall back on, we don't have a community to fall back on. And I do think that to this audience, I'd like to underline the point that this is not a natural community. This is scattered people all over the country who find 5 other people, 10 other people like them, who may find support, who may not find support. So it is a difficult community to bring together. It is a community divided by class, definitely, by caste, by our locations in multiple ways. How are we going to talk about issues that matter to the most marginalized is a question that we will have to take up front and then decide what our agendas are going to be. That is the second point that I want to make. The third point, I feel that if marriage, I now this is again, as a queer person, I ask all cishet people, can we minimize the importance of marriage in this society? Can we make marriage less important? Can we make family by blood less important? Can we think of ways of doing it? Can people get out of marriages even when they can get married? I think that these are questions that have been asked over and over again. And unless, the onus has always been on the margins to actually set up new alternatives. People who are troubled by these alternatives are not necessarily only the queer trans people. Everybody should be troubled by an institution like the family, which is so casteist, which is so hierarchical, and which is so invested in private property. So what are we doing about that? What are we doing about that as social movements? How are our demands that are coming from agricultural workers, from everybody else? How are we trying to say that family cannot be your only unit? There will have to be other ways to recognize people who are in other spaces. And I think that this is a question that we need to ask, we need to think, and we will need to move on that forward. I just want to again end on something optimistic that I see, is that I do think that the 3 judgments that came from the courts, the NAS judgment, the NALSA judgment, and the Narrain judgment, and the activism that went around to make them happen, I think that shows in the kind of discussions that we are having today. That shows the fact that we are not trying to now hide. We're not trying to hide behind names for ourselves. We are out here as queer trans people living our lives, asking questions, asking the so-called mainstream to talk to us. And the fact that we're able to do these conversations means that our struggle has to shift within society, yes, but I also agree with Akkai that it has to shift to a political dimension. There is no way that we can let this government be. This government was, in a way, I'm happy that this did not give us anything positive with this government in place. This government is against all marginalized populations. Can we at least talk to political parties to make commitments to what are they going to offer us? What are they going to offer us in terms of social securities? What are they going to offer us in terms of protection in employment, in education, shelter, etc., etc., etc. I think this is time to join hands with all marginalized people. This conversation has begun. It needs to go forward, and it needs to become part of all the other conversations that's happening, because all the time everybody thinks that we're only talking about gender and sexuality. I think for us, gender and sexuality is sorted. For people who are not living queer lives, maybe for them, there's much to think about their own gender and sexuality and the meaning of gender and sexuality in their lives. But for us, the concerns are really of life, livelihood, of basic requirements, and where are our support structures? And how do we hold communities, larger communities, and the state responsible to give that to us, to younger people, older people, dependent people, people with disabilities, all of us. I mean, family is a space that gives that, or is assumed to give that. So let's think of what are the alternatives to that.
Thank you to both Mihir and Chayanika for focusing both on the question of hope as well as the question of, concretely, where is the community as a result of struggle, and how struggle in the sense has resulted in the community having a certain kind of articulation today. And for really communicating that sense of hope, not in a narrow sense, but something which flows from the context of struggle. I think that's very powerful and very, very useful. Akkai, you already said all of this, but to ask you the question again, if you'd like to add a little bit, to the entire question of the way forward in terms of the political context. You, for example, Akkai, are a member of a political party. So do you want to tell us a little bit of how you managed to bring about a shift within the political party itself, and how you see that journey going forward, and what do you see as your vision in terms of where we go post this particular judgment?
Arvind, I received this invitation from the 36th Law Asia Conference 2023. You are confirmed as a speaker. I want to read this one paragraph to the information of the audience. Dear Dr. Akkai Padmashali, congratulations. We are pleased to inform you that the Papers and Technical Committee has selected you as a panelist at the session titled The Queer Family, Emerging Legal Issues on Saturday, 25th November 2023 between 12 to 1:15 p.m. under the stream Family Law. We believe that your fresh perspective on this topic would be building an engaging discussion at the conference. We look forward to your speak at the panel as a panelist at the 36th Law Asia Annual Conference. So this conference, I just heard that this letter was written by the President Sham Divan, the elect president of the Law Asia, the Supreme Court's one of the senior and topmost, advocates who fights for the rights of many, many sections and peoples of this country. When I received this invitation, I was so happy that I'm going to be part of this. I can talk about my Supreme Court, which will be supporting the judgment and stuff like that. When they also now mention the queer family emerging legal issues. So what I'm going to speak, Arvind? So I don't have specific answers toward this, and many countries, more than 15 to 20 country chief justices are coming together to Bangalore in the month of November, and I'm going to address them, speaking about the larger importance of gender and sexuality minorities are concerned. In context to the political movement is concerned, in Arvind, and in Bangalore, in the state of Karnataka, in South India, we have built a political matured movement. Any political party who believes the context of the ideological perspective grounds on the Ambedkar philosophy, Gandhian philosophy, or Periyar philosophy, Dravidian the philosophy, the left philosophy, many other philosophies, I think we are really able to do some sort of engagement with the government. I think my conversation with Ramki, why don't you, Ramki, take a lead to speak to the Tamil Nadu government? I think as a community, we should go together, keeping our differences aside. We should talk to people, talk to the state representatives. At least if we talk to one MLA and one member of parliament, that shifts some sort of change. Even after judgment is, when the judgment came on the 17th October 2023, except two political parties, CPI, who said it is disappointed. Congress said we are also disappointed. We are with the peoples of this movement, and we want to study the judgment. The Jatiyatita Janata Dal, they are not even able to understand the judgment, but they are open to listen to the voices of community. Very immediately I spoke to Rahul Gandhi's secretary, and we told this is a constitutional bench has come against the sexual minorities, saying that marriage is not a fundamental right to certain section of people. And I want to read this survey saying that when you're saying for the sexual minorities, it's not a fundamental right for her to go for marriage. And how can a system of justice can apply still for the heterosexual community? It is not only for sexual minorities. It is also shivering the base of the heterosexual normative people who are being part of this society. And keeping that as a next shift, the political movement has to be strong. And as I spoke to you, I think my conversation with the Chief Minister of Karnataka, please something set in the state of Karnataka so that we can become a model. If not the law, talk about the policy. That is some amount of activism is taking place. And I think going back to Chayanika's point, how do we consider as families? I want to remember the Delhi incident. When Sheila Dikshit was the chief minister, there was a gas burnt happen in Delhi. Where there was a big badai happening, there was a big jamaat happening. More than 30 to 36 people died in that burn. And Sheila Dikshit came to that spot and she said, Hijra community cannot be considered as a family. 2 days before she announced 5 lakh rupees compensation, then she says, no, we're sorry, we can't consider because this is not a biological family. And RSS, after the judgment, the Rashtriya Sarvana Sangh, they came to the forefront and they said, no, that is Rashtriya Sarvana, what's that? RSS. I call it as Rashtriya Sarvana Sangh, but it's supposed to be Rashtriya Swayam Sevak Sangh, like that, okay? So these Sanghs were celebrating the judgment. Oh, this has upheld the culture of this India, the tradition of India. What is culture? What is tradition without we? We are part of culture. We are part of histories. We are part of histories. We are part of tradition. You know, whatever the thing you can speak on, the context of mythology, context of Bible, context of Quran, we are part of that, yeah? Until this concept of majoritarian or a totalitarian is combated, it is so difficult for us to speak any sort of that language. I think this judgment has bifurcated the movement, and this government are wanting to only speak about the so-called social benefits, social schemes. As if something, they're doing something so new to the movement. I think accessing my right to health, my education, my employment, it's a fundamental duty under the Constitution. And how do we bring up this community language to such political discourse is my concern. But apart from this, this education and what do you say, this employment and stuff like that, I also have my privacy life, ma. I'm a married woman. I'm adopted a child. You know, I was married as a female in 2017, 2018 as registered marriage in the state of Karnataka. I'm attracted to Arvind. If Arvind is attracted to me, we both are marrying. If he's not consent, how can I marry Arvind? So it's about the consenting, the consensuality. It's about the willingness about the relationships. You know, I think transgender woman can marry a cis man. Transgender man can marry a cis woman. What happens to the people who are transgender women attracted to transgender woman, or female to male attracted to female to male? I think this discourse needs to happen within the community before we start dividing the movement or bifurcating the movement. It's a way forward, Arvind.
Thank you, Akkai. And really, I think all three speakers have communicated quite powerfully and strongly what role the social movements can play in bringing an issue to a wider public and to really getting this issue forward. I think the path being charted is something we have to reorient in a sense. The struggle.
Arvind, can I interrupt?
Please. You can always interrupt. Yeah.
I was also disappointed that the women's movement, that the social justice movements, the human rights defenders movement, the class and religious minorities movement did not even open their mouth. What is this? We're speaking the politics of convergence, and they're just quiet and they're so patient of accepting this judgment. That's what I felt. I think it's also the duty of our sexual minorities movement to converge all these movements together to make sure that they are going to respond to our concerns, our fights and struggles.
Thank you, Akkai. So a couple of points which emerge, I think, from all our speakers. One, of course, Akkai's last point is how do we see a convergence in the path going ahead? How do we, in a sense, see this this judgment as also linked to a broader politics of social morality triumphing constitutional morality? I think that's one dimension we obviously need to keep in mind. The second dimension is, of course, how do we reorient the direction of the movement in terms of what the speaker said, moving it from a completely legal focus to a larger social focus or a political focus, and how perhaps that might be one particular path forward as well. I'll end with that actually in terms of my bringing together all the thoughts of the three speakers. But I think we have time, so we can open it out to the audience. And if anybody has any particular questions to ask any of our speakers, please raise your hands, or Aishwarya, we can ask them to unmute and speak if possible.
Let them raise their hand, and I can.
Let them raise their hand and we'll take the call. Done. Okay. Are there any questions already in the chat? Kavita, do you have something to ask?
Someone
Vivek,
said.
please.
See, I'm sorry, I'm unable to switch on my video. Am I audible?
Yeah.
No, I just taking forward the points of our speakers, my worry is the women's movement. Actually, the kind of outrage that the women's movement should have expressed. At the end of the day, the entire business of marriage has been brought out from the framework of constitutional morality to social morality. And things, sentences like sacred, religious, all those kind of spiritual, things that have been said about marriage. And that's one institution that, women have suffered so much. So there is something about the women's movement. The silence is very worrying. Now I'm including myself in it. And I think Chayanika has stated a few things. But just to support Padmashali about other movements, I don't know about the other movements, but definitely the women's movement really, really needs to rethink. And we really need to sit together and analyze it from our point of view, from the point of view of the whole, how marriage has been looked at through this judgment, even from that point of view. And I think we have to dialogue with a lot of other groups and governments. Please remember that when the Supreme Court asked from state governments to give in their point of view, perhaps Rajasthan was the only state, the state where I come from, which gave the most retrograde affidavit. So somewhere I think this process of dialogue will have to be done even with governments. I mean, we should go, okay, the judiciary has betrayed us, but our process of taking it to the legislature, taking it to the executive doesn't finish. We should keep going back. So I also feel that we should redraft a memorandum in this backdrop and work on it. And of course, this judgment, I think, somewhere has come because of the RSS overwhelming point of view, which has taken over our society. I don't think this would have come, such a judgment would have come 4-5 years ago. But what's happened, so I think somewhere the fight against RSS has to factor in this also, their point of view prevailing on our, on our fundamental right to marry, and judges can so casually put it aside. Thank you.
Thanks, Kavita. Aishwarya, can we take the two other people who raised their hand and maybe our panel can respond to all three of them?
Yeah, Vivek has just been given permission to unmute.
Sure, thanks. Just a quick couple of points. Thank you for such an outstanding panel. I learned so much. Listening, I think, like Jay said, we've been caught up in reading the judgment of the last 2-3 weeks and then trying to decipher all of that was said. And I thought Mihir and Arvind did such a good job of really teasing out some of the key points. I think what Chayanika and Akkai did was remind us so vitally that this, at the end of the day, looking forward, we're going to have to base a lot of this within communities. I have just a couple of things to say about some of this. One, that I don't know if this is obviously not based on any kind of knowledge, but intuitively, I feel that maybe the women's movement did not respond in the way we thought it would, because I don't think this case was ever perceived as coming from the queer community for the longest time. I think it was seen as coming from certain quarters. And so I think the ways, so for instance, 377 and the way it really germinated as a voice of many, many people talking about this one issue, maybe, and the way we really intersected with other movements while working on the 377 case could be one reason why it garnered attention from other ecosystems and other collectives and movements. I'm not sure that this case did. And I think that also reminds us, at least certainly, of the value in actually basing a lot of this work within movements. I think the other thing I wanted to react to was Jay's point around working with other movements and intersections and talking about larger issues around the challenges to rights that are taking place across the board. And I totally appreciate that because it has a bearing on everything that we're speaking of here. but I just feel that that can be also a very intimidating idea for people to organize around, because it just is more complex. And so I'm just wondering, how can we think? I mean, I think that's a challenge and I think we should meet it. I'm just wondering how we can think about discussing that as a community. So that's another point I feel we really need to think about. And the third point I feel is that while we're feeling despondent, there is a lot to be said about, like we're meeting on Zoom here, I think the need to meet. And then from that meeting, let whatever emerge. But the need to meet would be probably a useful exercise just in feeling solidarity.
I think our next speaker.
Chitrajit, you can unmute right now.
No, thank you. I have a request and a question. The request is specifically from the legal perspective that people should stop running towards the Supreme Court at every single point that they get. There are ways to fight within the legal system than simply running towards the highest court because of whatever reasons. I don't want to get into that. And the question is, now that unanimously the 5-judge bench has said that marriage is not a fundamental right. Now, when we say that marriage is not a fundamental right, and then there are certain laws being passed in certain states where interreligious marriages are being targeted, are being made unnecessarily difficult, and it is also going towards even countering interreligious relationships. When marriage is not a fundamental right anymore, so how do we go towards that and how do we solve that?
Thank you, Chitrajit. Are there any more questions, Aishwarya? Or?
No.
I think the two we'll just take. I think because we won't get time to do another round. I think so. We'll take the two other questions as well. Shanthan and Maitri.
Maitri, you can unmute yourself now.
Yeah. Hi. I just want to take off from what Chayanika had said initially in her comments about marriage not being so central to a lot of people's lives, me being one of them. Do you think, to the panelists, this judgment might be an interesting way to break the idea that marriage has to be, or a natal family has to be the basis of all of the decisions and nominations that we have to make, and to say like, okay, marriage may not be a fundamental right, and as problematic as it may be, to not uncouple, but to keep away the idea of marriage from everything else. To say my healthcare right decisions, my life insurance nominations, bank nominations can happen without the right to marry, and that could perhaps be the next battle that we fight, rather than starting again from marriage has to be the basis for any of these things. Sorry, yeah.
Thanks, Maitri. Thanks. Shanthan, yeah.
Thanks, Arvind and Aishwarya, for organizing this. And thank you, the panelists, for such a great perspective on the law. I just wanted to kind of understand, given the global context of these kind of laws for communities, obviously this case was a big thing across the globe. So do you see any similar patterns in terms of legislations or in terms of progress with other countries, the US or other areas? And what do you think the implications can be, positive or negative, out of this judgment at a global platform? That's my question.
Thanks, Jonathan. So we'll get responses to whichever question you guys feel comfortable answering. Mihir, you want to begin?
Okay. One, the point about not rushing to the Supreme Court, taken, I agree. As a lawyer, I agree. I think I would just express that some of us were responding to what was happening. So, of course, there were cases in the Kerala High Court and the Delhi High Court, and then the forum moved to the Supreme Court. And we were concerned that without intervention and, as Chayanika put it, a more complicated set of discussions before the Supreme Court, that discussion would be incomplete. But I totally agree with you that rushing to the Supreme Court has its own follies. I think your question is something which is very much on our mind about how much damage has been caused to the other movements in terms of particularly the religious conversion laws and the restrictions on marriage and interreligious marriage, particularly that have come up in some states, the challenge of which is before the Supreme Court. Now, there are two things there. At a broader level, of course, not having a fundamental right to marry would limit the number of arguments you can make. But this judgment doesn't take away the fact that you can make constitutional arguments. One, because, first of all, those individuals are within the framework of marriage itself. So if there's a distinction, for example, on religion, certainly Article 15 prohibits direct discrimination on religion, for example. So all the traditional arguments that one might make in terms of restrictions on the right to choice of a partner and then recognition or discriminatory treatment on the basis of religion would still be available. So it's not completely off the table that loss would be there. I think one of the arguments that we certainly lost, and I think which was framed very well in court, was that if marriage is the fundamental right, then the notice and objection framework basically means that you're giving notice of the exercise of your fundamental right. You're telling people that I am going to exercise my fundamental, and that's how Raju Ramachandran framed it in court. Now that's gone. So the objection to the fact that you have to publicly notify your marriage, which is the same, sometimes you see that an iteration of that in the religious conversion laws, where if you're getting converted or there's an interreligious marriage, you have to notify the district magistrate, etc. I think that fight against that is a little bit more limited.
Thanks, Mihir. Chayanika?
So I want to respond a little bit to Vivek. I take the point that we've not been talking together for a long time. And this we is a very nebulous we. So there are groups that are talking to each other. I know that there was a national conference to talk about horizontal reservation for trans people that happened recently. I know that there are certain discussions that are happening have happened in the last year around family law, laws of intimacies. So there are pockets in which discussions are happening. I don't think the environment is such that all of us can sit together in the ways that we did in the early 2000s. There are many, many kinds of people around and many, many kinds of groups that are there. I think as an organization, we would try to see that the most marginalized needs, demands, and voices get centered in the discourses that we take forward. And that is a responsibility on many of us who've been here for very long or who've been part of these urban metropolis discussions around queer and trans issues. I think that to your other point about the women's movement not responding, I don't think that responses should be so that if you come and talk to us, then we will respond. That's not the way in which Kavita also meant, and I don't think that that's a fair thing to say, because a discussion around this has been going on. It is any discussion on marriage, whether it was whatever, it went to court, all women's rights people should be involved, all feminist movements should be involved. I would think by now other movements also should be involved. And I'm now kind of tired of trying to push everybody to speak on everything and take the onus of speaking of this issue. Because you are a women's movement, you must speak about marriage. Because you are this, then you must speak of that. I do think that at this moment, if we don't understand each other's issues and if we don't talk together on many things, then we are not going to be able to get anything in the world that we are living in. And we have to be cognizant of that. And having said that, I think the conversations with trans women and the women's movements have moved quite a bit. I do think that they move quite a bit across the country. That the fact that the women's movements in India have not responded in the ways that other countries have, and saying that no, you're not real women and so you cannot be part of us, etc., has not happened here. It is more inclusive. It is becoming more inclusive to trans masculine people as well. It's a slow ride, but it is nonetheless happening, and it's happening because people are talking at very, very grounded levels with each other. And I do think that this coming together of anti-caste discourses, of people from rural and working class backgrounds, and trans people and queer people together is something very heartening. So it is hence more of a disappointment that why are statements not coming out? Why are people not speaking? Maybe people are just too tired. Maybe there are too many things happening. Maybe there is, a frustration with the Supreme Court, which kind of says everything and then steps back. There are multiple reasons for it. And how many statements, what does a statement mean? But I do think that we need to take this now to the next level, and we have to do it with everybody else. It will not be done only by queer trans people. It cannot be done only by us. It has to be done with everybody else, because our issues are not only about familial violence. Familial violence leads to a plethora of issues which connect us to every other margin. And I would take my point and think more about how do we now argue if marriage is not a fundamental right, then what is a fundamental right? As far as my intimate spheres are concerned, what is fundamental to me? Can we start discussing that in larger groups? And I really urge people to shun marriage. Whoever has a right to marry, please get out of it.
Thank you, Chay. I think Malvika had something to say, and Akkai as well. Okay.
Malavika, you want to go ahead, Malavika?
You'll need to unmute, Malvika. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮಾಲ್ವಿಕಾ ಅವರೇ? ನೀವು ಅನ್ಮ್ಯೂಟ್ ಮಾಡಬೇಕು. I don't think they can hear us.
Yeah, so till she joins us, I have only one suggestion, recommendation to make through this forum, Arvind. Number one, we should, having this conversation, I think you have really brought us together to at least to think and see what could be done for the future of the movement is concerned. I would really suggest and recommend that there should be a national core committee that we should come together for what? To speak to other movements, to talk to governments, to talk to your political structures, systems, leaders. That's very much, utmost need that I would say. And in Karnataka, we already began to speak to all the sections of society that includes the civil society movement, the governments and political leaders and parties are concerned. I think I would say that we should come together. Let's have this national core committee, and we also want to have funding. Akkai will not come, like that, because we're a non-funded organization. Our bank balance is 26,000 rupees. I can't, come to Bombay. I can't come to Delhi. So that's our status. So how do we raise money locally, friendship-wise, whatever? I don't know that strategy, but we should come together, raise money, have this core committee, and function for this movement cause.
Thank you, Akkai. Malvika, are you there or?
ಕೇಳಿಸ್ತಿದೆನಾ?
ಮಾತಾಡಿ.
Okay. ನನಗೆ ಇಂಗ್ಲಿಷ್ ಅಷ್ಟು ಬರಲ್ಲ. I will try. If marriage is not fundamental right, let's think whether it disturbs any other fundamental rights given by our constitution, one thing. And if no marriage is no family, having family is a human right. I think that, and we can go again Supreme Court to rethink ಮರುಪರಿಶೀಲನೆ with unity. ನಮ್ಮಲ್ಲಿ ಇದ್ದ ಎಲ್ಲಾ ಜನರು ಕೂಡ ನಾವು ಒಳ್ಳೆ ಪ್ರಿಪರೇಷನ್ ಮಾಡಿಕೊಂಡು ಯುನಿಟಿ ಆಗಿ ಅದು ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೇಕು ಅನ್ನೋದು ನಂದು ಒಂದು ಸಜೆಷನ್ ಇದು.
Thank you, Malvika. Thank you so much. We'll end with that, but I think the range of thoughts have really.
Translate what you said, Arvind.
Malvika basically said that we shouldn't give up. We should find a way of taking this issue forward. Is there a way going back to the court in terms of? I think she used the word actually review, Marupali Parishilane. So, is there a possibility of going for review? Is the question that she asked. Yeah? So, yeah. So we will. I thank you for the range of thoughts and comments which have really come in the course of the entire discussion. And I think everybody is right to indicate we should see this as the first discussion, as the initiating of this kind of a conversation. And we should discuss how to take this forward in terms of either an offline meeting or continue a bit of the online discussions and see how we can all meet and take this kind of a discussion forward. And just in terms of I think the human rights groups itself and the fact that the PUCL has taken a position on this in terms of the judgment and the statement has been issued from the PUCL. So there's a level in which the human rights groups understand the implications of this. And Kavita's particular formulation, if you got that, the way she put it, is what this judgment does is reinforces the notion of social morality and puts aside the notion of constitutional morality. And therefore, from the human rights movement point of view, it's a blow. And therefore, we need to think of how to take forward again the broader discourse of constitutional morality. Again, that's the point which Mihir made very strongly, saying the Special Marriage Act is rooted in the notion of constitutional morality. And it's our role as a human rights movement, as a larger discourse, to take forward that issue of the liberatory or the emancipatory potential of the Special Marriage Act, such that you recognize the rights of all persons. And again, the point being that sometimes we may not achieve everything through marriage, but perhaps we can achieve everything through another route as well. And that's a point for future discussion. I think on that point we'll end, unless Dr. Suresh from the General Secretary of the PUCL would like to come in with some concluding words.
You can unmute now, sir.
Okay, thanks, Arvind. I mean, the panel's discussion has been fantastic and a lot of new insights have come. Just very briefly, since we are ending this whole exercise, I think what might be useful would be to summarize the key issues thrown up because of the judgment. Like what Chayanika was saying, if marriage is not a fundamental right, then what else is a fundamental right in the context of intimate relationships? I think a set of these issues, because this is election time, this is the time if on behalf of many of us who think, irrespective of our different opinions and different stances, write it up as a position paper and circulate it to all the political parties. And wherever, for example, on behalf of PUCL, we can say that wherever there are PUCL units, whichever state we have units, we can ask them to organize panel meetings. Because Akkai's issue about we don't have the resources to go from place to place, but we definitely can try out in our local areas. I would like to only share one experience I have had during the whole hearing. This entire issue of the public hearing and the publicity it got has broken the glass ceiling about talking about issues of the LGBTQ community. As a lawyer in the court, a lot of people were talking. And right now, when I circulated the poster for this meeting, at least about 10 lawyers got back to me saying, this is extremely interesting. We want to know more about it. We don't think what the Supreme Court did was right. Now, these are people I would never expect are anywhere close to activism. They're nothing to do with activism. So somewhere this shaking up has taken place. What was a taboo subject has now come out in the open. I think that is one small positive thing that has come. So I would suggest that if we can come out with a small booklet and a small questionnaire type of a thing, which can be taken and this debate has to be taken to trade unions. This has to be taken in the various social movements. This issue will have to be taken at various other levels so that the discussion continues. So towards that, I think, Arvind, you already stated it. We have taken a stand, and on behalf of PUCL, we would like to say that we will definitely take it forward. And it's not a PUCL stand. It's something that many groups, rights groups will have to come together. And there is no better time than an election time, because in this cacophony of noises, this is the best time to push it forward. So I think that would be very, very interesting. So if we can capture, say, about 8 to 10 key issues that are coming up based on the judgment, looking at it futuristically, what would be the issues that we raise? for a discussion and a debate and circulate that would very positively take the entire issue forward. Not, I mean, there are goods and bads about the judgment. While we continue to debate it and talk about it, I think we need to keep going forward and raise these issues. We could also consider a virtual medium in which we get the women's movements to come, trade union movement to come. We formally invite them for a discussion on this. That could be one positive way to go forward. So I would think that a lot of possibilities have opened up with the way the ruling has come, which we should make use of to expand the larger discussion and the debate to areas where people would never have talked about it. Trade unions, you cannot talk about, I mean, you can never think about talking about LGBTQ rights. Now, as a law office, I have had trade unionists come to my office in the last 6 months, some of whom would, by the way, talk, sir, what did you think about the judgment? What do you think about the discussion that's going on in the Supreme Court? I don't remotely think that they would talk, but now they're coming to talk. So this glass ceiling has broken, and we should keep on breaking it so that we expand the democratic space. Thanks, Arvind.
Thank you, Dr. Suresh. On that note, I think we'll say thanks to everybody, and thank you for panelists in particular. Thank you so much.
Thank you.